Let's call the case of Lynn King versus Nakia McDonald. Thank you, counsel.
Thank you.
This case opens like a routine landlord-tenant dispute, but underneath the surface, it's already loaded with legal tension. What you're about to see is not just a disagreement over unpaid rent. It's a direct collision between what a lease says and what the law actually allows. And that difference is where most landlords lose cases like this. At first glance, it seems simple. A tenant fell behind, the landlord applied late fees, and now the court is here to settle the balance. But the moment numbers start getting discussed, something feels off. The amounts being claimed don't just look high, they look disproportionate. And in a courtroom, disproportion is a red flag that immediately triggers scrutiny. The judge, Judge Simpson, is already in analytical mode. He's not reacting emotionally. He's listening for inconsistencies, gaps, more than anything that doesn't align with legal standards. And the second late fees begin to dominate the total amount owed, the direction of this case is set. This is where many landlords miscalculate. They rely on the lease as absolute authority. But in reality, the lease is only valid if it aligns with the law. And this case is about to demonstrate that distinction with precision. Watch closely how the numbers unfold, because once the breakdown starts, the entire structure of the landlord's claim begins to weaken.
Well, they may be able to stand it. I think they can. They'll stand it. All right.
Your Honor, this is Lynn King.
All right.
Nakia McDonald.
All right. All right. Where are we on this case? There was 1760 owed the last time that we were here.
Yes.
We talked about the late fee issue. Were you guys able to work something out?
She paid July rent after like several days, 11th of this month. So her balance is reduced to $865.86. That is include May, June, and July late fees and the utility.
So this amount is May, June, and July late fees?
Yes.
Okay, and go ahead. And what else?
There's a $70.86 utility, and before she set up her DTE account, so I paid for her.
$70.80?
Yeah, 86 cents.
86 cents. And then what else?
And
Anything else?
55 court fee.
For the court fee?
Yes.
All right. So if I take this 55 and if I take the $70, $55, and then the 86 cents, but if I do that, so of this 865, 86, all the rest of that are late fees.
Yes. It's on the lease. $5 per day is the lease.
Oh, I know.
Yeah.
I think you have that broken down for, so how many, hang on, give me 865. Well, I can do it myself. That's okay. 125, 04.
Here's the first major shift. The judge takes control of the math. That alone tells you something is wrong. Judges don't usually calculate unless they suspect that the presented numbers are either unclear or misleading. And as he starts breaking things down, a pattern emerges. The majority of the balance isn't rent, it's late fees. That changes everything, because rent is enforceable. Late fees, on the other hand, must pass a reasonableness test. This is where the landlord's position begins to weaken. When penalties start outweighing the original obligation, courts start questioning intent. Are these fees meant to recover costs or to punish the tenant? The judge is methodically isolating each component: utilities, court costs, and then what remains. By doing that, he strips away anything legitimate and exposes the core issue, a heavy concentration of penalty charges. This is no longer about missed payments. It's about whether those penalties are legally justified. And once that question is on the table, the burden shifts entirely onto the landlord.
So I have $740 in late fees. So how many months is that?
That's from May. She hasn't paid late fee since.
Hold on a second. I'm trying to, I'm not asking what she didn't pay.
Okay.
I'm saying this $740 are late fees for how many months?
3 months. Actually, July,
Okay.
she paid it on 11th, that's earlier. So that's only count for 10 days, in July, for July rent only.
I don't know what that meant.
Like May, she didn't pay late fee.
Hold on a second.
Okay,
So for July, her late fee was only $50.
yes, July, there's a $50 plus 5 days. So on the lease, it says if after 5 days she didn't pay, or whoever the tenants, well, $50 initial fee, and the plus 5 days times 5. So that's $75 on July before she paid. Then $50 on, plus 5 days per day on June rent, that was $170. And May rent was the most.
That all sounds really nice and pretty, but listen, I'm trying to figure out that even if, give me 740 minus 75.
665.
So if I take July out of the picture.
Yeah.
And it's $75. She has paid for 2 months. You want to charge her $665 in late fees.
For the May rent,
How much is her rent?
the rent is $520 on her portion.
Right. So effectively, just bear with me here. You want to charge her about, my math is right, about a month and a quarter of what she pays for rent as late fees.
This is where the case becomes undeniable. The judge converts raw numbers into a real-world comparison, and suddenly, the imbalance is obvious. Charging more than a full month's rent in late fees is not just aggressive, it's legally questionable. Courts look for proportionality. A fee should reflect the inconvenience or administrative cost of delay, not exceed the rent itself. When it does, it starts to resemble a penalty rather than compensation. And penalties are where legal problems begin. The landlord's reliance on "it's in the lease" is collapsing here, because even if both parties agreed to it, the court can still invalidate it if it's unreasonable. That's a critical legal principle. Contracts cannot enforce unfair or excessive terms. This moment is also psychological. The judge is forcing the landlord to hear the numbers in context, not as isolated figures, but as a ratio. And once framed that way, the argument becomes much harder to defend. This is the turning point. From here on, the judge is no longer exploring, he's challenging.
Yes, Your Honor. Yeah, because I really encourage tenants.
Hang on a second.
Yeah.
I understand you said yes, Your Honor. Does something sound wrong to you about that? That was a question.
I calculated based on the lease,
Okay,
day by day.
I know what you did. I'll say it again. You're charging her $665 in late fee. Her rent is somewhere around, her portion is around $500.
520, yeah.
You're going to charge her for 2 months late fees that are the equivalent of a month and a quarter of her rent. Now comes my question. Does something sound wrong to you about that?
Well, I just tried my best to encourage tenants to pay on the time because it's irregular, totally out of my control.
Oh, I don't think it's out of your control.
Because I need tenants to follow the lease to pay so that I book on time. But if it's irregular, I'm totally, because her sheet has been
You
individual.
cannot, your late fees on any lease, the law is that they have to be in some way related to the cost of collecting rent.
This is the legal foundation of the entire case. The judge clearly states the rule. Late fees must be tied to actual cost, not hypothetical inconvenience, not frustration, actual, provable cost. And then he introduces a critical concept, liquidated damages. When fees are fixed and excessive, they can be classified as punitive rather than compensatory, and that's where they become legally vulnerable. What the judge is saying is simple but powerful. You cannot profit from someone being late. You can only recover what it cost you to deal with that delay. This completely undermines the landlord's structure. There's no evidence presented that $5 per day reflects any real expense. It's just a number written into the lease. And that's not enough in a courtroom. At this point, the case is no longer balanced. The judge has identified a legal flaw, and now everything moving forward will revolve around correcting it.
It also indicates that they cannot be liquidated damages. This sounds a whole lot more like liquidated damages than it does related to the cost of collection of rent.
I'll take your advice, Your Honor.
Oh, you don't take my advice. I don't give advice. I give orders. So I understand she may have been late. I get that. But I also understand that you would have to show me that somehow or another you spent $5 every day trying to collect her rent.
Yes.
Outside of the fact that, mind you, a portion of her rent you got already
Yes.
because you get it through the subsidy.
Yeah,
So
that's right.
that's the other part that's silly about this. You're charging her $5 a day, but part of her rent is guaranteed to you. Is it a HUD subsidy you have, ma'am? Then I think also the $5 a day per their lease is illegal. You can't charge it.
I think that's the lowest charge on the late fee, as I know, from the real estate market. I've talked to the Ann Arbor Real Estate Society and the society. They provided this number for me.
Okay, here's what I'm gonna do, because you're not listening to me. I'm gonna send you two out. You go out, figure out what might be a fair amount for her to pay given her circumstances and related to any effort you had to collect it. You guys come back to me with a number. If I don't like the number, I'm gonna tell you what it is.
Okay.
Because it seems to me I can talk all day and night long telling you this $5 a day you can't charge. I told you that on Zoom. I'm telling you that today. I'm trying to explain to you why you can't charge it today. You're not listening to me. You're saying it's on paper. That's fine. I don't mind if the agreement between the parties is reasonable. That I don't mind assessing. But this is de facto unreasonable.
Okay, I'll
To
take.
charge her that. And ma'am, understand something. You may want to teach everybody in the world a lesson. That's not your job to teach everybody a lesson. It's not your job to teach them to pay on time or to do whatever. Because sometimes, and I see she's got those two little babies there, she's running around at times to robbing Peter to pay Paul.
This moment shifts from legal analysis to human context, and that matters more than most people realize. Judges don't operate in a vacuum. They consider circumstances, intent, and real-life impact. Here, the judge acknowledges something critical. The tenant isn't refusing to pay. She's struggling to keep up. That distinction changes how the court views the situation. This is not avoidance, it's recovery. By bringing up her children, the judge is highlighting financial pressure. He's not excusing late payment, but he's reinforcing that life circumstances must be considered when evaluating fairness. This is where rigid enforcement fails. The landlord is treating the situation as a numbers game. The judge is treating it as a legal and human balance. And those two approaches are now in direct conflict. The instruction to negotiate is not optional, it's strategic. The judge is giving the landlord one last chance to adjust before the court imposes a solution.
Because that's just life sometimes, right?
Yeah, I understand.
So you can go out there. It seems the two of you can at least get along and talk.
Mhm.
Come back to me with a number. If I don't like it, I'm going to give you my own number.
So
Because it's all just 2 months plus a little change that she was behind.
okay. By the way, there's another portion, and it's security deposit. She started from December 2024, and because I saw her little babies and in the winter, and so I accepted her to move in before the security deposit was paid. So, but it's not paid so far. For
Is
7,
that in this 865?
no, it's separate.
Well, I'm not dealing with the security deposit. Because
Okay.
you got enough problems with the illegal late fees.
Yeah. But this is also something I need to collect.
You guys go figure out. I'm not dealing with the security deposit. You guys go out.
Okay.
Figure out a reasonable amount.
Mhm.
I'll then determine if it's reasonable, and I'll tell you what she's gonna pay on that. And then I'll tell you how she's gonna pay.
Okay, I got a
But
question.
give you guys time to try to work it out.
Thank you. And I have a question. When can we give you the response before next in person or online?
Oh, you just go out into those little rooms. You're gonna
Okay.
decide this today.
Now the pressure increases. The judge is accelerating the timeline. There's no delay, no extended negotiation. This is being resolved immediately. This is a courtroom tactic. When a judge senses that one party is not adapting, they compress the decision window. That forces clarity. It eliminates the ability to stall or avoid accountability. At this stage, both sides are expected to return with a reasonable number. But the expectation is clear. Reasonable does not include excessive late fees. The judge has already rejected that framework. This moment also exposes something important. The landlord is still trying to anchor the discussion around the lease, but the judge has already moved beyond that. He's operating on legal standards, not contractual terms. And that disconnect is what's keeping the landlord on the losing side of this exchange.
So we can turn in our result to you.
You go out there, you talk, I'll pull your case back up, probably first part of the next block. Thank you.
Okay, thank you.
Or Rico's case, People versus King, or not People versus King versus McDonald. Why are you leaving them back there? They did well. Come on up. They can come up and sit right up here. They came up, sat quietly. They behaved themselves. I don't know. Well, this one was having a, no, I'm just saying. All right, folks.
You are not.
The parties are here. What did we agree on that I'm gonna tell you I'm probably not gonna let happen?
She said she'll pay the July rent on 23rd. Is that right?
The July,
July rent. She's still all the July rent, 520 on 23rd of this month.
didn't she already pay her July rent?
I saw, I counted as July rent, but she meant for July 11th, she paid for June. So that's, she considered as paying June on July 11th. But I thought that was her July rent. So we saw differently, but I count her payment as part of it.
Okay.
Yeah. So I tried to work out July rent. She said she'll pay on 23rd of this month. I accepted. And her last utility bill was $70.86. And she'll pay me after this, or when would you like to? Okay. I appreciated her efforts, and I can cut off her because she paid on June 11th for May rent. That's what she counted for. So I cut off the late fee.
Hold on
Yeah.
a second.
Yeah.
Ma'am, how much is your portion of monthly rent?
520.
This is a reset moment. The judge brings the conversation back to basics. Rent. Because once things become confusing, the court simplifies. By asking for the rent amount again, he's reestablishing the baseline. Everything must be measured against this number, and once that baseline is clear, the imbalance becomes visible again. You can also see confusion between the parties about what has been paid and what hasn't. That's another critical issue. Misapplied payments can create artificial debt, and courts are very strict about how payments are allocated. The judge is cutting through that confusion. He's not allowing assumptions. He wants clarity, precision, and consistency. This is where many cases collapse, not because of disagreement, but because of poor accounting. And that's exactly what's being exposed here.
Okay, so of this 865.86 that you told me is owed, you're telling me now that 520 of that is actually rent?
July rent.
No, what she's adding is late fees. She's adding the 50 plus $5 per day. July rent is not even added in here, I don't believe.
But because we're thinking the July rent differently, she thought that was I consider as July rent included, but she considered her July rent should be paid later.
No, something's going on.
No, my checks were being garnished, so that's why I fell behind in the first place. So now I'm playing catch up. So I
Right.
do need to pay July rent, which I will be able to pay this Wednesday in full. But there is late fees. That is her $850 and something. That's the
So what she technically owes really should be the 520 plus this 860, whatever.
I believe so, yes.
That's what I counted for May, but now I count only for.
This should be easy to figure out. Either she's paid July rent or she hasn't. I'm sitting here July, they're doing just fine. Leave them alone.
Okay.
I am July rent. So, okay, let me ask you this. Is the reason why we're having a problem as to whether or not July rent is included is because she's taken some of that money for late fees?
I don't agree with the late fees. I think I should be charged one late fee per month.
Well,
This is the tenant finally asserting her position clearly, and it aligns directly with what the judge has been indicating from the start. She's not rejecting responsibility. She's rejecting the scale of the penalties. That's a crucial distinction. Courts are far more receptive to arguments about fairness than outright denial. Her mention of wage garnishment adds another layer. It provides a legitimate explanation for the delay. And in legal terms, context matters. It doesn't erase the obligation, but it influences how the situation is judged. This strengthens her position significantly, because now the case is not just about numbers. It's about whether those numbers are fair given the circumstances. And at this point, the judge has already shown where he stands on that issue.
I'll get to the late fees. But when I sent you guys out, you told me her July rent was paid, that the only thing that she owed is this amount. And then we broke it down to where there was $125, basically, because she had the utilities of the 7086 and then the $55 court cost. And that took 125 off of that. Then I asked a very specific question of whether or not whatever was left was late fees. Remember me asking that?
You're so clear-minded. I thank you so much, Honor. And I counted May rent was not paid, but she counted her May rent was paid on June 11th. That's what we get together when we were in the courtroom, and we figured out, okay, I accepted her as June 11th paid the May rent. But prior, I thought the May rent was not paid at all so far. So that was the difference. So she counted as paid on July, that's 1.5 months later, paid May rent, and then another 1.5 months paid June rent. Then now she's paying the July rent. So I do accept her, explanation. I do. So right now we clarify it as her May rent and the June rent has been paid, but just late. And her July rent will be paid next Wednesday. So I agree with that. We kind of communicated for this.
I don't care how you put these numbers in. How much are you claiming she owes?
I just cut off her portion as late fee. So I accept your advice. I would charge only $150 for May rent late and $150 for June rent late.
You're not getting $150. That, ma'am, you're charging her a late fee.
Yeah.
That is, if you charge $150 per month, potentially for her late fee, it's almost a third of what her portion of the rent is.
But she was 1.5 months late. How can I manage my property with all this late fees? I mean, all this late, I have to pay tax on time. My tax is pretty high, much more than the rent. So I need to pay off my tax.
Right. And you could also end up owing money if you were charging an illegal late fee. Yes, legally you could.
But I didn't charge it illegally. It's based on the lease that $50 initial charge and $5 per day. That's the agreement.
You're going to pay your rent on the 23rd, 24th?
Yes, sir.
Get it paid by the 25th. So she's going to pay her July rent by the 25th. There's going to be then a decision on the $865 of late fees for 3 months. I'll give that decision August 1st, 2025 at 12 p.m.
This is where the judge formalizes the outcome timeline. He's taking control of the resolution and making it clear that a decision is coming, and it will not favor excessive fees. Notice how he explicitly warns the landlord. This is not subtle. He's saying that not only will the fees be reduced, but there could be legal consequences if the current structure is maintained. That's significant, because now the risk shifts. It's no longer just about collecting money. It's about potential liability. This is a turning point where smart litigants adjust immediately, because once a judge signals this level of concern, pushing forward with the same argument becomes dangerous.
So I will give you my decision as to what late fees can properly be charged her. And it's going to be nowhere near that figure. I'm letting you know that right now. I'm going to give you an opportunity because you keep pointing to the lease. You might want to go speak to an attorney. Because if I have to come back and make this decision, and I'm not saying that I'm going to do it, there are going to be certain truth in renting issues that accrue to this tenant. And you could potentially end up owing her money.
But I want a number, if you could honor.
Pardon?
I like to have a number. I don't have idea. How can I manage this?
I can't answer some of that. I can only suggest to you that you may want to go talk to an attorney about what you can charge. I will give you some guidance, and that is that the typical HUD lease, which still has its problems depending on what that person is paying as their portion, will say either $25 to $30 on the 5th, and then $1 per day, which would then be approximately $50, $55 per month as late fee.
Here, the judge provides a benchmark, not a ruling, but guidance. And that guidance is dramatically lower than what the landlord is claiming. This is the court showing what reasonable actually looks like. And compared to the original numbers, the difference is massive. This reinforces the central issue. The landlord's fees are not just high, they are disproportionate. And in legal terms, disproportion often equals unenforceable. The judge is essentially giving the landlord a blueprint to correct the problem. But whether that blueprint is followed is another matter.
How if it's not paid on the month?
Pardon?
How if that is paid after that month or later, even later?
There's a whole issue with your accounting because however you're applying her payments are first in, first out. She may have been behind, and she just told me she was behind because of a garnishment issue. That's fine. But there's a huge difference between somebody facing almost $740, I guess, late fees for that period in time. And if I were the guidance I'm trying to give you of say 50, 55 a month, and are facing $150 late fees, there's a huge difference in that. In particular, where somebody's rent, their portion, which you figured out by a calculation, is 1/3 of her income, basically about a third, that you're going to then charge an additional amount of housing costs. That makes no sense. It is, and quite frankly, I'll just tell you right now, it's unconscionable that you would try to charge them. You're not out every month when she doesn't pay on time. I get it that she should be paying on time. People run into difficulties, but you're not out that entire amount of rent because you're getting a portion of that rent paid. It's her portion that is not being paid.
Mhm.
And it's not like she didn't pay it. It's not like she's just bailing. She's just got to figure out how to recoup, get herself back to ground zero. That's all she's trying to do.
Okay.
But she can't get back to ground zero if you keep charging these. She can't get there.
Okay. I accept.
So
Can we?
you guys are going to come back. You're going to get my decision. You need to go talk to a lawyer because you're going to end up in a whole lot of trouble with that lease.
If I agree to reduce
You're going to end up in a whole lot of trouble with that. I'm also going to give her an opportunity to talk to a lawyer if that's what she wants to do in terms of enforcing her rights, because it's illegal. I told you that the first hearing. And then get here and Nobody wants to believe me. We'll see you on the first. Thank you.
Is that?
Hold on, what? What is it? 3 p.m.? 8-1 at 3 p.m.
Zoom or in person?
It's in person.
Okay.
This one needs to be.
Okay.
Okay? All right? So it'll be 8-1, 3 p.m.
This is the final warning, and it's as direct as it gets. The judge is telling the landlord that continuing on this path could lead to legal consequences beyond this case. He's also balancing the scales by giving the tenant the same opportunity to understand and enforce her rights. That's a key aspect of judicial fairness. At this point, the outcome is clear. The excessive late fees will not stand. The only question is how much they will be reduced, and whether the landlord avoids further liability. This case is a textbook example of a critical lesson. A lease is not absolute authority. It must operate within the boundaries of the law, and when it doesn't, the court will step in and correct it. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.